What's up, guys? Welcome back to Kitchen Court Cases, where we watch court in my kitchen. And today we are looking at two similar cases, but different outcomes. They are arraignments, and they are both for drinking and driving charges. I hope you enjoy.
You wanted to, but first, let me advise you of the charge and of your rights. The charge alleges that on or about June 29th of this year, you operated a motor vehicle on I-75 in Otsego County while under the influence of alcohol, and while a person less than 16 years of age was occupying your vehicle. If convicted, you face up to a fine of up to $1,000 plus up to 1 year in jail. Do you understand the charge and the maximum possible penalty?
Yes, sir.
Your rights include the right to an attorney. If you could not afford one and wanted one, the court would appoint one for you, or you could proceed without an attorney. You have the right to a jury trial in this matter. If you wanted a trial but not a jury trial, you had the right to, or you could request a bench trial. At that trial, the prosecutor would be required to prove your guilt beyond a reasonable doubt. If the prosecutor could not do that, the matter would be dismissed. At that trial, you'd have the right to remain silent. If you chose to remain silent, that silence could not be used against you. On the other hand, if you wanted to testify, you could. You'd have the right to have the court subpoena or order witnesses on your own behalf to be present, and you'd have the right to have you or an attorney ask questions of witnesses against you. Do you understand your rights?
Yes, sir.
All right. Do you plan to hire your own attorney, seek a court-appointed attorney, or proceed without one?
Court appointed.
All right. Mr. Brown, have you had a chance to interview Mr. Devan?
I have, Your Honor. I have forwarded that information to Mr. Gilo's office. I do believe he would qualify.
All right. So, sir, assuming that that is verified by Mr. Gilo's office, an attorney will be approved for you. Do you get your mail at 7 in Sault Ste. Marie?
Yes, sir.
All right. You've already posted bond. Conditions that would typically be added on something like this would be not to consume or possess alcohol or drugs unless those drugs are prescribed for you, and that you would not drive with any underage children, that is, anybody below age 18 in your vehicle during the pendency of this action. Do you have any questions about that?
No, sir.
All right, Mr. Fenton or Mr. Brown, anything else in this matter?
He had a very high blood alcohol level, Judge, and he was driving very poorly. And he has a prior back in 13, which is too old to enhance. I don't know if the court would consider adding some testing, if not daily, then at least random, 1 or 2 or 3 times a week. I don't know if you have the authority to assign him to OCC because it's a misdemeanor, but something to that effect I think would be helpful.
What was his blood alcohol level in this?
It was above a 0.20. Let me just double check. 264 on a PBT, and we're awaiting a blood test.
Mr. Brown, any comments on that?
Your Honor, he does live in UP. He has a 7-year-old daughter he has to take care of. He's currently on disability. I'm not sure what that disability is for, but as was previously mentioned, his criminal history is over a decade old. I mean, I would just ask court to take some of those things into consideration here.
All right, well, Mr. Devan, is your daughter the person who is, you don't need to tell me any other details about it, but is that the person who was in the car at the time you were stopped?
Yes.
Okay. I suspect there may be some hardship. All this case is ongoing, but she cannot be in the car with you, when you're driving.
I understand.
Okay.
Yes.
And you cannot consume alcohol. That's a bond condition. That's going to be on lien. So if the police stop you, you have a minor child, you have any consumption of alcohol, even if in theory it would be legal, you will be written up for a bond violation. You'd be very likely to wait out this case in jail. Do you understand that?
I understand, sir.
I'm not going to adopt that recommend or the request for testing, but I'm really on the fence about that right now. So you'll be notified as to who your attorney is in your next hearing date. You just understand the conditions of the court at this point. Okay, thank you. Bond is continued.
Thank you, sir.
All right. Sir, are you Ronald Fournier?
Yes, I am.
All right, this is an arraignment. The charge against you alleges that on or about July 2nd of this year, you operated a motor vehicle while intoxicated by alcohol. It's charged as a third offense. And as an habitual offender, fourth offense. So if convicted, you face up to life imprisonment. You understand the charge and the maximum possible penalty.
Yes, I do, sir.
All right. Okay, all right, your rights include the right to an attorney. If you could not afford one, the court would appoint one for you. You have the right to a jury trial in this matter. If you wanted a trial but not a jury trial, you could request a bench trial. At that trial, the prosecutor would be required to prove your guilt beyond a reasonable doubt. If the prosecutor could not do that, the matter would be dismissed. At that trial, you'd have the right to remain silent, and if you chose to remain silent, that could not be used against you. On the other hand, if you wanted to testify, you could. You'd have the right to have the court subpoena or order witnesses on your own behalf to be present, and you'd have the right to have you or an attorney ask questions of witnesses against you. Do you understand your rights?
I do, Your Honor.
I'm seeing that you have requested a court-appointed attorney, I believe, but the information that we have is that one is not appointed because you do not qualify, which presumably means you have too much income in that regard. We'll see how things
Yes, sir.
stand after the rest of this hearing. Mr. Fenton, as to bond.
Filled out a bond sheet on this, Judge, and I'd ask you to take a close look at it because by my count, he has 6 prior OWI thirds and 9 prior DWLS convictions, along with many dismissals as part of plea agreements. Now, what I failed to note on there, and I didn't realize it, even though his name sounded familiar, but I have verified that he has another OWI third case pending, which is up for Thursdays for a prelim review. So he's on bond for a drunk driving third. Now he commits a new one. He's a 4th habitual offender. So my bond request had been 10,000. I'm increasing that to 20,000 cash or surety.
I think he's supposed to have a machine.
Okay, all right. Mr. Brown, any comments?
Your Honor, he is relatively local. I believe he lives in Grayling, which is very close here. I don't think he's any kind of a flight risk. I don't know if there's any issue of failing to appear for court, so I don't think that's any kind of an issue here. The only issue I think is going to be public safety. And if he is currently on bonds for another case, I'm not sure who his attorney would be for that. However, if he is on bond, he already is going to be complying with certain conditions that he has to follow. He does have a full-time job. He makes a relatively decent living. He currently lives with his wife. So what I would ask the court to take some of those things into consideration when setting the bond here. One of the primary issues is going to be him appearing in court. He's always going to appear. And as far as some of these other ones, I'm not sure what these other convictions are or how old they are. I would ask the court to look at that, maybe take that into consideration as well.
Well, looking at the charging document, the alleged other offenses in 2019 OWI third, 2012 OWI third, 2006 OWI third. What I've heard from the prosecutor is that there's another charge that's still pending, perhaps up in circuit court.
No, it's here.
Oh, that's right. It's here coming on Thursday.
I thought Mr. Fournier was doing Smart Start.
Do you have a Smart Start, Mr. Fournier?
I do.
All right, that's a complication in one sense because it makes me wonder, at least with these allegations, how you're able to get it started. You don't need to answer that question now because that would get into what did or did not happen on this. But I know we're coming here on Thursday on that case. Do you have an attorney in that case?
I do,
Who is
Mr.
it?
Gilo. Mr. Gilo.
Did you retain him or was he appointed?
I retained him.
All right. Well, I'm going to set this for a hearing on this Thursday as well. We can do a bond review, but I'm greatly concerned by this. I'm going to set bond at $50,000 cash as surety. The concern that I have is with the Smart Start that's supposed to be there, and maybe there's an answer. What it is escapes me right now, but there's 3 convictions and now 2 pending charges that at least there's allegations that you're using alcohol. So the court will set that at $50,000 cash or surety. If you are released, there would be daily testing. A smart well, if their Smart Start was ordered, that would continue. And the request is no driving if you're released, and I think that is appropriate along with reporting to community corrections. So bond is set at $50,000 cash or surety.
Thank you, Judge.
All right, but I will also, as I said, set a hearing on Thursday. At least you can talk to Mr. Gilo about it. If you're going to remain incarcerated, my guess is you're going to then be eligible for a court-appointed attorney. Okay.
Yeah, I'm gonna
thank
lose
you.
my job if I stay here. All right, thank you, sir. I got a phone call now.
Well, guys, what did you think about that? Obviously, drinking and driving is very serious. 4th charge, but it sounds like there was more that were dismissed. I'm glad the judge set a high bond at $50,000 there. That is probably the right thing to do in this situation. I would love to hear what you guys think down below in the comments. Also, if you liked this video, I will post a card somewhere on the screen that has a link to another DUI case, but these ones were pled down. I bet you'll enjoy. Thanks.